I'm having handy two more order. Just my colleague is bringing within a minute. Before this, Your Lordship, I just want to apprise regarding the order passed by this honorable court, the 9th February order.
Yes.
Yes, Your Lordship. In 9th February order, if Your Lordship refer to paragraph number 2, 3, 7, 9, 13, and 4.
Yes.
To Your Lordship, that what is the case the petitioner has filed claiming themselves the owner of petitioner number 1, wherein we are saying we are still the owner since 1997, 1 and 2. Then, Your Lordship, paragraph number 7, where the issues has been narrated. What are the issues? With reference to NCLT, the case has been filed. Now,
No, this order
yes,
by which the petition was dismissed,
yes,
then there was a review file.
yes,
It was allowed.
yes,
What was the ground for recall?
exactly. So, if Your Lordship come to the paragraph number 14, there were two grounds on the basis of which this petition was dismissed. One, that it was recorded in the order that NCLT proceeding is pending. Number two, as per section 8 subsection 1 under Arbitration Act, when there is as per the judicial authority seems to be NCLT.
Arbitration. Company. Yes.
Yes. I have, Your Lordship, an extra arbitration report.
We have. Yes. So it's an error apparent admitted.
Yes. So the ground for the dismissal was two grounds. One is judicial authority, which I have stated last occasion as well, and one is pendency of matter before NCLT Kolkata. So for the pendency, it was recorded that it is pending, but during the time of hearing, it was pending. But when they have filed the arbitration application, that time we have not filed. We have just served the copy of petition of NCLT. After receiving of
Mr. Counsel.
Yes, Your Lord.
By the subsequent order, which is 12-6.
Yes.
The earlier order of dismissal has been recalled.
If Your Lordship can refer to the same order, paragraph number 2 and 3.
Yes.
Paragraph number 2 says the review impugned order passed on the basis of prior to filing of this section 11 subsection 6.
No, you are referring to para 2 of?
Para 2 and 3 of this review order.
Review order, yes.
Yes. So they have revived, Your Lordship has revived the CP only on the ground that there is a pendency recorded. If we are leaving that pendency, then also the question of section 8 subsection 1 remains. Judicial authority. Last time, on the last occasion, Your Lordship has asked me a question that is there any bar? Is there any bar that arbitration proceeding can take place? So Your Lordship, under section 8 subsection 1, when there is already a specific provision, specific court available, why to come into general forum? Then also not only
because of the agreement.
And agreement, what is it is saying, Your Lordship? Number one, jurisdiction issue still remains because it is regarding the ownership of the company. Company means property. And I have two judgments I'll cite. One is Booz Allen.
Section 8.
Yes.
Is for those cases.
Yes, Your Lord.
On the mistaken belief on which your petition was dismissed, that you have already approached, brought before a judicial authority. And subsequently, at the time of at the time of coming to the arbitration, there was already a matter pending. But this, the court has held, is not correct on fact.
Yes, Your Lordship, with reference to pending, it is correct on fact. I am not going that I have served the copy of petition much before they have filed this arbitration petition. I have filed the NCLT proceeding much after, that is after 4 months, means after they are filing of arbitration petition, that is an admitted fact. But then also, I'll just rely, I can, with reference to jurisdiction, I just rely two judgment. One is Vidya Drolia, and
So the recent judgment of the apex court
yeah,
regarding the interpretation of understamped document, that reference made to the larger bench of Stamp Act and Arbitration Act.
Hmm.
There the court has held. The ratio is that once there is a decision between the parties, the jurisdiction is to be left to the arbitral tribunal to decide whether this matter can be decided by
Your Lordship, then also it is with respect to the ownership of the company.
Whatever
Kindly
it may
look
be.
into their petition.
Whatever you are urging here, you urge before the tribunal.
Your Lordship, kindly look into the petition once.
We
I
don't
just
want
refer
to.
to the cause title.
We don't want to. In view of the law settled by the apex court, you refer to the judgment. It's clearly dealt with
That is-
Vidya Drolia and all the other
Para,
judgments,
para 131, madam.
of all the other judgments, making it very clear that even in a case where the original document was understamped or not stamped and is not admissible in evidence, if there is an arbitration, is a reference to arbitration by the parties, then it has to be excluded. Court can look into this under 11.6, whether there is a agreement referring the matter to arbitration, save and except those standard procedures that already the matter is pending before the court or in a subject which is out and out not capable of being arbitration, to be decided in arbitration.
Understood, Your Lordship. Your Lordship, by allowing this, Your Lordship, that petition will become infructuous. Why? I am challenging that I am still the owner.
And
They are saying over here
this is a
that they are the
petition-
owner and they are representing
this is a
respondent.
petition under 11.6.
Hmm.
This is a petition under 11.6. So the parameters, the area of 11.6 has been defined in the recent judgment by referring to all the precedents. So the consistent view of all the precedents, as well as the view, the law settled by the apex court, that when there is a provision, matter should be referred. That's all we are required to look into. Whether this matter can be decided through arbitration or not, or whether the arbitral tribunal so constituted has a jurisdiction or not, it can be looked into by the tribunal itself.
Your Lordship,
And then you have the right of appeal as provided under the Act.
Your Lordship, then also that Buzalen and Vidya Drolia says that if there is
Those judgments will now have to be read in view of the definitive and authoritative finding of the larger bench.
I'll just refer, if Your Lordship permit, I'll just refer 2 or 3 paragraphs from Buzalen and Vidya Drolia, Your Lordship.
You refer the judgment first, and then you tell me the extent of relevance of this paragraph. The latest judgment, it's an authority, it's authoritatively held that where in 11.6, all we need to see is whether there is an arbitration agreement. Once it is there, once the parties have agreed, the authority, you can take all the grounds available before the tribunal to form.
Your Lordship, then I'll have to go through that judgment. For that, I'll seek one more day if Your Lordship permit that judgment, because provisions of Companies Act is itself a complete code, and accordingly NCLT's bench has been set up. Now they are claiming that they are the owner.
But you agreed to an arbitration in an agreement. You were a party to that agreement.
Then Your Lordship, mediation is also there in Companies Act.
When was this agreement signed? Before NCLT or after NCLT?
Much before NCLT.
Much before NCLT. Then your redressal forum would be Company Law Board.
Yes.
It was already there. Yet you signed. It's an agreement. You're not challenging this agreement that this is forged or
No, but there is an
there's falsity involved.
yes, with reference to transfer of shares, there is a forge, and I have filed
That is the
criminal
we are
cases also
not on
pending.
we are not on the issue which is debatable. We are on whether this agreement
Hmm.
subsists or not. Agreement to refer to arbitration.
Then,
That's
Your
all.
Lordship, I have an NCLAT judgment, NCLAT, where it says
You want us to follow NCLAT judgment in the face
No,
of the
Your Lordship.
judgment of the apex court?
Not at
It's
all, Your
binding
Lordship.
on us on the 141. You know that.
Then, if Your Lordship can permit, I'll just go through that judgment. I need one more day. On 20th, if my learned senior friend is available.
28.
20.
20.
That's Friday.
You can have it on 11th also if you want.
No, Your Lordship, I am coming from Kolkata. No,
We have VC facility if you want.
Your Lordship, I'm staying alone. I'm having 6 months old baby. So I have to manage a lot of things.
All the more reason why you should have VC facility.
Then, yes,
You want it on 20.
20th, Your Lordship. I'll just get time to go through that.
20? Yeah. Heard? Parties. Senate Council or the respondent, Mr. R.K. Kesri, submits that the issues which are stated to be subject matter for arbitration and for which the present petition under 11.6 has been filed are within the domain of the NCLT and for which necessary petitions have already been filed by the respondents. So submits that since these issues, since the question of the arbitrability of the issues are required to be decided, first, the matter would require some hearing. So, Mr. J. Roy Leonard, Senior Counsel, appearing for the petition, submits that the apex court has laid down, has authoritatively laid down the power and scope under of the high courts, of the courts under Section 11.6 of the Arbitration and Conciliation Act in a recent judgment
2024 6 SEC page 1.
2024 6 SEC page 1 within bracket regarding so and so, so, and so. Give the name also. You know. So he submits that this judgment has elaborately considered all the other precedents and has held that while deciding a petition under Section 11.6 of the Arbitration and Conciliation Act, all the court needs to do is to find out whether there is an agreement, whether the parties have agreed to refer to arbitration in case of any dispute that may arise between the parties. So, there are Mr. Kesri, learned counsel for the petitioner, craves leave of the court and submits that he would like to address the court in respect of this judgment on some other date. He prays for some accommodation in this matter. As agreed to by both parties, is the matter again on 2009.
Much obliged, Your Lordship.
We can have it on an earlier date. Why wait for 20? We can have it on 18th.
18th, then actually my calendar was tight.
All right, 20.
Permits.
20th of September. Yes.
Dr. Brad, Dr. Saraf has already concluded his argument. We'll file a
Yes, yes,
written
yes.
submission.
We were supposed to file the written argument.
Yes,
And
Lordship.
some,
Lordship, this is the written argument. Some corrections have to be done. This was the application that private.
see, what I don't know
Yes, yes.
what the counsel for the petitioners would like to submit on this, but this is a document which will have to be referred to in this matter. So propriety demands that you should bring it by way of an affidavit, by giving them,
Yes, Lordship. But Lordship,
we'll permit you to file a short affidavit,
yes, just bringing this
just
on record.
bring this on record.
Yes.
Right? So that it remains on record. Otherwise,
Yes,
there is no record how this document has come into the court record. The counsel for the petitioner has concluded his argument and craves leave of the court to file written submission. Stop. The counsel for the respondent, however, submits that the application filed by the
Varun.
industry who has been granted the benefit of extension of the exemptions and whose case has been referred to by the present petitioner to plead, to urge that the respondents have adopted to discriminatory tactics while allowing the exemptions for the said industry and at the same time rejecting the claims of the writ petitioner. He is available, has been furnished to him by the department. He would like to file an affidavit to bring it on record. So, notwithstanding, considering that, considering the prayer of the respondents, let the affidavit be filed within a period of 2 weeks.
Lordship, within 3-4 days, I can.
Giving you 2 weeks, you file it within a period of 2 weeks. And after service of copy on the respondent, on the petition. Stop. In view of the affidavit being filed, petitioner is given liberty to make his submission in respect of the said affidavit if the petitioner so desires. List after 2 weeks on a date to be fixed by the registrar.
File your
2, 3, 4. You can take it back.